I got it right here.
Alright.
Search warrant. Police, open up the door. Police, open the fucking door.
Yeah, it looks like no one's home. Police, open the door, we're breaking in.
Alright guys, kicking in the door.
Yo, hold up. Let me see if the door's unlocked. Fuckers. Let's roll in.
Police.
Boys. Hey, Sarge. You guys find me at home?
It seems like no one's home, Sarge.
No? You guys find anything?
Yeah, it's a fucking rainforest downstairs. About 1,000 plants.
Yeah? How big are they?
Huge.
Huge?
Fucking monster.
Fucking huge. Like we're gonna get ready to crop that shit. Did you guys find anything else?
Just the phone and the computers.
Yeah. Did you guys search the computers?
No, don't we need a separate search warrant or something like that?
Ah, that seems search warrant's good enough, right? It's like a fucking file cabinet or a cupboard, you search it, whatever. So yeah, just search those phones, I mean the computer and the phone too, but do that as well.
Alright.
Alright, find anything, Irvin?
Looking through his Facebook right now, Sarge. And he left his MSN chats open. Even got his resume right here.
Fucking resume.
Yeah.
Ah, might as well leave a blood trail. Good job. Oh, you, Neil.
You got something? Hold on, Sarge. What vehicle is he on?
I think a black CRV.
Well, seems like I got a clear shot of a black CRV in the dryer right here in the records.
Yeah?
It was...
Alright, you want to do just take a picture of that. The more evidence for us. What do you, Cyrus?
Yeah, this fucking idiot left his phone unlocked. These two even took a fucking selfie.
Let me see it.
Fucking idiot.
Oh, fuck.
Fucking goof.
Yeah. Alright, here's what we'll do. We'll bag and tag all this stuff, and then we'll call a hazmat, come and fucking jump downstairs on the grow up. And yeah, get out of here. Alright, good job, guys.
Alright.
Good job.
Good job, guys. All rise.
You may be seated. This is the case of R. V. Vu, brought up from the Appeals Court of British Columbia. The appellant, Mr. Vu, is appealing the decision of the Appeals Courts based on a Section 8 Charter Violation. This court will look at each issue at bar separately. I shall be brief with one issue. I agree with the Court of Appeal that the facts provided in the ITO were sufficient to support a reasonable inference on the part of the issuing justice that documentation evidence, ownership, or occupancy would be found in the residence. Issue 2 is whether the warrant permitted the police to search for documentation on the computers and cellular telephone found in the residence. The parties shall provide their arguments.
Mr. Justice, we contend this matter has already been addressed by this court in Hunter v. Southam Incorporated 1984. Additionally, the traditional legal framework holds that once police obtain a warrant to search a place for certain things, they can look for those things anywhere in the place where they might responsibly be. The police do not require specific prior authorization to search in receptacles such as cupboards and filing cabinets. Mr. Justice, we contend computer searches fall within the purview of this framework. Furthermore, it was reasonable for the officers to search the computers for proof of ownership or residency in part because the warrant specified computer-generated documents. We would like this court to also consider the understanding of the term documents by the Appeals Court of British Columbia in this case. Specifically, paragraph 53 to 58, essentially the term documents extend to electronically stored information. Furthermore, if Mr. Vu had a high expectation of privacy as he claims, wouldn't he have been more prudent by not leaving the computers running or by placing a password on them? This, we rest our case.
Thank you, Mr. Justice. We believe the question of whether prior or further authorization is required has already been inferred by previous court decisions. This is a fundamental question of how far we are willing to let the state interfere without privacy. We would like you to consider the following cases. In R.B. Jones, 2001, Ontario Court of Appeal, paragraph 49 stated, "There seems to me to be no reason in principle why the state should be any more entitled to roam around through the contents of a person's computer in an indiscriminate fashion than it would be to do so in a person's home without further authorization," end quote. In R.B. Cole, 2012, in this court, I bring your attention to paragraph 65. The police seized the laptop and CD in order to search their contents for evidence of a crime without the consent of Mr. Cole and without prior judicial authorization. Furthermore, R.B. Cole considered a person to have reasonable expectation of privacy even on a work-issued computer. This protection surely extends to a personal computer, Mr. Justice. In R.B. Morelli, 2010, also in this court, Justice Fish stated, "It is difficult to imagine a search more intrusive, extensive, or invasive of one's privacy than the search and seizure of a personal computer." Mr. Justice, we contend a personal computer should not fall within the scope of the traditional search framework, as my colleague has brought up. The information stored inside a computer is too vast, too private, and too connected to be considered on the same grounds of a file cabinet or a cupboard. There should not be an open-door policy to the most intimate details of our lives. For these reasons, we rest our case, Your Honor.
This court's determination on issue 2 is this. Privacy interests implicated by computer searches are clearly different from those at stake in searches of receptacles such as cupboards and filing cabinets. It is difficult to imagine a more intrusive invasion of privacy than the search of a personal or home computer. Computers potentially give police access to an almost unlimited universe of information that users cannot control, that they may not even be aware of, may have tried to erase, and which may not be, in any meaningful sense, located in the place of search. Thus, the court determines the search, in this case, to be contrary to Section 8 of the Charter. However, it is not this court's aim to create a search regime as a rule requiring computer search warrants to have specific search protocols. Yet, this does not give police a blank check in the way they carry out their search. It was to be within reason. Having already determined the search to be unlawful, we come to issue 3. In determining whether the evidence found in the search of the computers should be excluded, one has to apply Section 24, subsection 2 of the Charter. In this court's opinion, the inclusion of the evidence would not bring the administration of justice into disrepute. The reasons are as follows. Reason number 1. Here, the ITO did refer to the intention of the officers to search for computer-generated documents. In considering that the state of the law with respect to computer search was uncertain when police carried out their investigation, and the otherwise reasonable manner in which the search was conducted. The violation was not serious. There was a clear societal interest in adjudicating on their merits. Charges of production and possession of marijuana for the purpose of trafficking. Thus, I would dismiss the appeal and uphold the order of the Court of Appeal, setting aside the acquittals entered after trial and directing a new trial.